Inventive step or non-obviousness in patent law. Another requirement for patentability is that the invention must have an inventive step or is non-obvious. An inventive step or non-obviousness means that an invention must not have been obvious to a person skilled in the art or one of ordinary skill in the art. It can be said obviousness means that if any person of average skill in the scientific or technical field of the invention could have put together different pieces of known information and arrive at the claimed invention, then that invention is not patentable.
In the United States, the inventive step or non-obviousness is governed by 35 U.S. Code Section 103. 35 U.S. Code Section 103, Conditions for Patentability, Non-Obvious Subject Matter. A patent for a claimed invention may not be obtained, notwithstanding that the claimed invention is not identically disclosed as set forth in Section 102, if the differences between the claimed invention and the prior art are such that the claimed invention as a whole would have been obvious before the effective filing date of the claimed invention, to a person having ordinary skill in the art to which the claimed invention pertains. Patentability shall not be negated by the manner in which the invention was made. In the United States, obviousness is a question of law based on underlying factual inquiries. The factual inquiries are as follows. A. Determining the scope and content of the prior art. B. Ascertaining the differences between the claimed invention and the prior art, and C. Resolving the level of ordinary skill in the pertinent art. Objective evidence relevant to the issue of obviousness must be evaluated. Such evidence is sometimes referred to as secondary considerations. Secondary considerations may include evidence of commercial success, long felt but unsolved needs, failure of others, and unexpected results. The evidence relevant to non-obviousness may be included in the specification as filed, and accompany the application on filing. The evidence may also be provided in a timely manner at some other point during the prosecution.
A person skilled in the art. A person skilled in the art is a hypothetical person. He is presumed to have access to all publicly available prior art information. He has the capacity to understand all technical matters in the scientific or technical field relevant to the claimed invention. He also has the general knowledge and ordinary practical skills common to the field. This person will also have the capacity for routine experimentation to, for example, clarify ambiguities on known technology. The person skilled in the art does not, however, have inventive capabilities beyond the capacity to exercise the usual faculties of logic and reason to combine the knowledge. This person is not expected to exercise inventive imagination, to add knowledge to the prior art and to advance the technology. Sometimes, this hypothetical person should be presumed to be a group of persons or a team of specialists, each of whom has a particular skill. The level of skill and knowledge of a person skilled in the art may vary depending on the particular technological field involved. In general, the level of knowledge and skill of the person skilled in the art is not the average of a layperson, meaning the minimum knowledge and skill, or a leading specialist's skill, meaning the maximum knowledge and skill. The person skilled in the art is rather the skill expected of an ordinary, duly qualified practitioner in the relevant field. Reasoning that may support a conclusion of obviousness. The following may conclude that the purported invention is obvious. A. Combining prior art elements according to known methods to yield predictable results. B. Simple substitution of one known element for another to obtain predictable results. C. Use of a known technique to improve similar devices, methods, or products in the same way. D. Applying a known technique to a known device, method, or product, ready for improvement to yield predictable results. E. Obvious to try, choosing from a finite number of identified, predictable solutions, with a reasonable expectation of success. F. Known to work in one field of endeavor may prompt variations of it for use in either the same field or a different one based on design incentives or other market forces if the variations are predictable to one of ordinary skill in the art. G. Some teaching, suggestion, or motivation in the prior art that would have led one of ordinary skill to modify the prior art reference or to combine prior art reference teachings to arrive at the claimed invention. Thank you for watching. All the links are in the description below. Leave a comment below. Give this video a thumbs up. Click the subscribe button. See you next time. Goodbye.